Hello guys, and welcome to another episode of my channel. On today's episode, we'll be talking about hearsay evidence. Now, what is hearsay evidence and how do they come to play when it comes to law of evidence? Those are the things that I'll be discussing in this particular lecture. So let us start with my notes. Then subsequently, after reading my notes, we can then talk about the explanation. So yes, hearsay evidence is also known as unoriginal evidence. So when you are talking about hearsay evidence is the opposite of direct evidence. Do you understand? Where direct evidence is talking about the person who saw and can speak to the fact in issue, for example, hearsay evidence is talking about somebody who heard and is currently saying. Do you understand? That's why it is called unoriginal. Do you understand? Now, it is also known again as second-hand evidence, as we can see the case of FRN versus USMAN, or derivative or transmitted evidence. This evidence has been described judicially also in the case of Ojo versus GBARORO and OKPALA versus the state. Now, in the often cited case of SUBRAMANIan versus police prosecutor, the Privy Council held that the evidence of a statement made to a person by himself who is himself called a witness may or may not be hearsay. Do you understand? It is hearsay and inadmissible when the object of the evidence is to establish the truth of what is said and contained in the statement. It is not hearsay and is admissible when it is proposed to establish by evidence not the truth of the statement, but the fact that the statement was made. Now, before I continue with the notes, I need you to understand that when you are talking about hearsay evidence, first of all, anybody who did not see a particular thing occur but heard someone speak about the events of that thing occur, whatever that person is coming to say is totally hearsay. Do you understand? So let's say something happened in a particular lecturer's office, and then some students were there, but Tayo was not at the lecturer's office at that time, and then Tayo came to meet me, and then Tayo is telling me, oh, I heard it from Tosi, that Tosi said, because Tosi was there, Tosi said that this and this and this is what the lecturer did. Now, what Tayo is telling me would not be hearsay if what Tayo is telling me is that this is what Tosi said. That means that she's only narrating what Tosi has said, telling us that this statement was made by Tosi. That's a different thing from when Tayo is narrating the whole incidents at the lecturer's office. If she's the one narrating the whole incident at the lecturer's office, telling us as if she were there, what actually happened there, that would be hearsay. But if she's telling us that this is what Tosin said as to what happened in the lecturer's office, she's only telling us, okay, this is what Tosin has said. That's not hearsay, because she heard Tosin say it. But if she's telling us that this is what happened in the lecturer's office, that's the truth as to what Tosin has said, that's a different thing. If she's testifying to the truth of the substance of Tosin's statement, is hearsay. But if she's just telling us that this is what Tosin has said, it is not hearsay. Do you understand? So that's how hearsay work. And when you are quoting hearsay in your exam or in a mock trial or something, it is very, very important for you to quote the case of SUBRAMANIAN versus police prosecutor. Very, very important. And the Nigerian case, which has also given that SUBRAMANIAN's case authority, is the case of Ojo versus GBARORO, and also the case of FRN versus USMAN. These are very, very important cases when we are dealing with hearsay. So now let's continue. Hearsay evidence is also evidence which does not derive its value solely from the credit given to the witness, but which rests also in part on the veracity and competence of some other persons. Now, when you are talking about this, we are saying that a person has come to give hearsay evidence. Why? Because what the person is saying, for us to determine whether or not is the truth, then we have to rely on the statement of another witness. The moment that is the case, then it is very likely that this person has come today to give us hearsay evidence. Do you understand that? So now, Tayo, like I said earlier, Tayo is currently seated in the witness box, and Tayo is narrating as to the incidents that happened in the lecturer's office. And then the next question is, Tayo, they asked Tayo, were you at the lecturer's office? Tayo said no. Where did you hear this story from? From Tosin. it's obvious that because Tayo was not testifying that Tosin told her, but Tayo testified as to what happened in lecturer's office, it means what Tayo has said is hearsay, because we cannot derive the authenticity of that statement from Tayo's statement. Do you understand? We have to listen to what Tosin has to say on the matter. And the moment we are shifting, from one witness to another witness on the same subject matter, it means that that first witness is likely to have given a hearsay evidence. Do you understand what I'm saying? So yes. Now, 2 reasons for excluding hearsay evidence. Number 1, the memory of the witness may be ineffective, or narration of events may be incorrect or deliberately falsified. Number 2, the court would be deprived of the opportunity to watch the demeanor or the outward manner of the witness to determine whether or not he's saying the truth. Now, this is very, very common in Nigeria. Not even in Nigeria, as human beings. When something happens, there is always this tendency in us, to want to always add jara, like we call it, add jara to statements. And that's the reason we need to exclude hearsay evidence. Because something happened, and let's say it's just as simple as ABC that happened. Let another person come and narrate it. More ABCD. Let another person come and narrate it. A B C D E F. We want to add our own extra on top. Do you understand? So that's the reason we have to be wary about the kind of evidence that is being admissible in courts. And that is why, as a general rule, hearsay evidence is deemed inadmissible. That is, if we look at section 37 of the Evidence Act, hearsay evidence is deemed inadmissible. And another reason is because when the judge is watching the witness in a trial, the witness has a particular demeanor and all that. The judge can tell whether or not this witness is saying the truth. Demeanor is the way you compose yourself when you're in court. So there's a way a witness will compose himself. This one be like, say this one don't they lie. Do you understand? And then there's a way a witness will compose. You will know that, this person is actually saying the truth. I really want to get to the root of this matter. Do you understand? So when you then bring another person to come and testify to what actually happened, which he was not there, now he's now relying on the statement of another person. How do we know when the person is saying the truth or not? To his own best knowledge, he can only relay to the extent at which he was told, which is hearsay. Don't forget that it will not amount to hearsay if he's only coming to tell us that this is what he heard. That's not hearsay. But if he's coming to tell us that, this is what happened, however he was not there, he heard it, then that's hearsay. Do you understand? So yes, in my next lecture I'll be talking about material witness versus credible witness. See you in my next lecture.